The Fair Labor Standards Act, or FLSA, is a federal law governing wages, hours, and working conditions. Although Sandy City policy may provide for more generous benefits, this training addresses primarily the FLSA standards. Per the FLSA, each employment position is classified as either exempt or salaried, or non-exempt or hourly, and the two classifications are treated differently. Human Resources will determine whether a position is exempt or non-exempt. To find out if an employee is exempt or non-exempt, you can check the job description or contact Human Resources. Exempt employees are compensated on a salary basis. They generally must be paid a full salary for any week in which the employee performs any work, and they are not generally paid overtime. Because the city provides employees with paid time off, or PTO, the FLSA allows the city to require exempt employees to use PTO for certain absences. However, if an exempt employee works over half the day, they can count it as a full day worked without supplementing with PTO. The city cannot make deductions from an exempt employee's pay for partial week absences related to jury duty, witness duty, or military leave. However, the city may offset against the employee's salary any amounts the exempt employee receives as jury fees, witness fees, or military pay. The city is not required to pay an exempt employee's full salary for the week for unpaid leave due to discipline or FMLA leave. Non-exempt employees must be paid for all hours worked in a work week. In general, hours worked include all time that an employee must be on duty or on the employee's work site. Each work period stands alone in computing hours worked, and employees must not average hours over 2 or more work periods. A work period for non-exempt employees is 7 days. If a non-exempt employee works more than 40 hours in a work period, they must be paid overtime at the rate of 1 1/2 times the overtime hours worked. However, overtime must be approved in advance. If an employee fails to get advance approval, the city must pay the employee for all overtime worked, but the city may discipline the employee for working overtime without approval. The following are not considered work time and are not paid: unpaid absences or leave, jury duty, and time spent before, after, or between regular working hours which is unrelated to principal work activities. On-call time is not considered work time and is not paid until the employee is actually called back to perform work or the on-call time is overly restrictive. The following may cause or contribute to overly restrictive on-call duties: excessive geographical restrictions, frequency of calls, required response times, use of pagers, and the ability to do personal activities while on call. Each department should avoid imposing too restrictive on-call requirements. For those departments that pay for on-call, although not required by the FLSA, the city's on-call rate is $25. Lunch periods are not required by the FLSA, not considered work time, and are unpaid if they are at least 30 minutes and the non-exempt employee is relieved of all duties and free to leave their duty post. Supervisors should make sure that lunch periods meet these criteria. For the city's policy regarding lunch periods, see page 10 of the Employee Handbook. Full-time non-exempt employees receive 2 15-minute rest breaks, each one taken around the midpoint of each 4-hour segment of work. Employees working part-time shifts of 3.5 to 5 hours receive 1 15-minute break. These breaks are considered work time and are paid. Employees may not save their breaks or combine them with other breaks or lunch periods. However, supervisors should encourage employees to take their rest breaks. Non-exempt employees who are nursing mothers should be given additional non-paid rest breaks for up to 1 year after the child's birth for the purpose of expressing breast milk. The frequency, duration, and length of these breaks may vary based on nursing mothers' needs, and they are entitled to the use of a private location other than a bathroom. These rest breaks are not considered work time and are not paid unless the employee chooses to use their 15-minute paid breaks. Training time is considered work time and is paid unless all of the following are true. 1. The training occurs outside regular work hours. 2. Attendance is voluntary. 3. No job-related work is performed while attending the training. And 4. The training is not directly related to the employee's job. Training or continuing education as a condition of practice of a profession not tailored to meet the particular needs of the employer is not considered to be work time and is not paid. Time spent at out-of-town trainings or conferences is considered work time and is paid. However, meal periods at such trainings are not considered work time and are not paid. Generally, commuting from home to work and from work to home is not considered work time and is not paid. However, if a non-exempt employee has a fixed work site, all same-day travel other than commute time is considered work time and is paid. If a non-exempt employee does not have a fixed work site, travel from home to the first work site and travel from the last work site to home is not considered work time and is not paid, even if the travel is over an abnormally long distance. This is true unless the employee works during the commute. If a non-exempt employee works remotely for part of the day, driving to and from the work site may be considered work time and paid if it is considered travel between work sites. For example, if the employee works remotely in the morning and travels to the office in the afternoon, the travel would be considered work time and paid. If the employee returns home and continues to work, the travel time is work time and paid. If no additional work is performed after leaving the office, the travel time would not be work time and is unpaid. Overnight and out-of-town work-related travel may be considered work time and paid. The time that an employee spends driving out of town for work is considered work time, and the employee is paid for all driving time. Furthermore, time spent traveling as a passenger during regular work hours, or the weekend equivalent, and any time actually spent working while traveling is considered work time and is paid. If the travel time is outside normal work hours and the passenger is not working, the travel time is not considered work time and is not paid. If flying, travel to the airport, waiting at the airport, or traveling on the plane is not considered work time and is not paid unless it is during normal work hours or the weekend equivalent, or the employee is working during the travel time. The general FLSA rules regarding non-exempt employees also apply to police officers and firefighters, but with the following modifications. 1. The number of hours that a non-exempt firefighter can work before overtime begins is 182, and the number of hours that a non-exempt police officer can work is 86. A work period is 24 days for firefighters and 14 days for police officers. 5 hours of the 24.5-hour shift is sleep time for firefighters. This is not considered work time and is not paid. However, if the firefighter is not able to have 5 hours sleep between the hours of 10 p.m. and 6:30 a.m., the entire 5 hours will be paid time. Fire and law enforcement personnel on shift work may choose to substitute or trade shifts. Trading shifts does not count toward overtime hours worked for the week as long as it is 1. Voluntary, 2. For the employee's benefit, and 3. Approved in advance by the supervisor. The city may provide comp time instead of paying for overtime hours worked. In order to do this, there must be a written agreement on file in Human Resources between the employee and the city. A copy of a comp time agreement is contained in Appendix 20 of the Supervisor Guidebook. For each hour of overtime worked, the employee accrues 1 1/2 hours of comp time. Firefighters and police officers may accrue a maximum of 480 comp time hours, or 320 overtime hours worked, and all other non-exempt employees may accrue a maximum of 240 comp time hours, or 160 overtime hours worked. Each department may set a lower maximum, so make sure that you know your department policy. All overtime hours worked above the maximum must be paid as overtime. Departments may also choose to allow employees to accrue comp time for hours worked that are not overtime hours. The city may choose to pay off an employee's accrued comp time hours at the overtime rate at any time, and all comp time accrued at an employee's termination must be paid out at separation. Unlike a vacation or other PTO leave request, you must allow an employee to use accrued comp time whenever they want, unless the employee's absence would unduly disrupt the operations of the department. If their absence would unduly disrupt the department's operations, you must allow the employee to use their comp time as soon as it would no longer disrupt the department's operations. The FLSA does not allow city employees to volunteer for the city unless the volunteer work is substantially different from the service the employee is employed to perform. If an employee wants to volunteer for the city, please check with Human Resources to verify that they will be considered a bona fide volunteer under the law. Refer to page 8 of the Supervisor Guidebook for the volunteer hiring process. The FLSA child labor provisions govern the employment of minors. A minor is defined as someone under the age of 18, but age 14 is the minimum age for employment. The following regulations apply to minors between the ages of 14 and 15. They cannot work more than 3 hours on a school day or 8 hours on a non-school day. They cannot work more than 18 hours in a work week when school is in session, or 40 hours in a work week when school is not in session. They cannot work more than 8 hours in any 24-hour period. They can only work between 7 a.m. and 7 p.m. except during the period between June 1st and Labor Day, when evening hours are extended to 9 p.m. They are limited in the types of work they are allowed to perform. Some examples include office and clerical work, cashiering and concessions, lifeguarding for 15-year-olds only, custodial work, and grounds maintenance that does not include the use of power-driven motors or cutters. Minors between the ages of 16 and 17 may be employed for unlimited hours in any occupation other than those listed in Appendix 21 of the Supervisor Guidebook, which are declared hazardous by the Secretary of Labor. However, only minors at least 17 years old can operate a vehicle, and only under the following conditions. 1. The minor must complete the driving authorization for minors and the moving violation disclosure statement before operating a vehicle. These are found in Appendix 22 of the Supervisor Guidebook. 2. The gross vehicle weight does not exceed 6,000 pounds. 3. Driving is incidental and occasional to the minor's employment, meaning that no more than 1/3 of a workday and no more than 20% of a work week are spent driving. 4. Driving is restricted to daylight hours and within 30 miles of the place of employment. 5. The minor holds a valid state license for the type of driving involved and has no moving violations at the time of hire. 6. The minor has completed a state-approved driver education course. 7. The vehicle is equipped with a seat belt, and the minor has been instructed that it must be used. 8. The driving does not involve towing vehicles, route deliveries or sales, transportation for hire of property, goods, or passengers, urgent time-sensitive deliveries, or transporting more than 3 passengers including other employees. 9. The driving does not involve more than 2 trips away from the primary place of employment in a single day for the purpose of delivering goods or passengers other than employees. Note that these rules apply whether the minor is driving a city vehicle or a personal vehicle. Departments that have 17-year-old drivers must keep a log of the date, destination, mileage, and driving time for each trip. You are responsible to understand this complete section. Please take the time to read over it in the Supervisor Guidebook. Please contact Human Resources with any questions.